Mr. Landau, we've taken the view that the 7 points which you outlined for us before lunch are sufficiently covered in writing in your case, so you don't need to take us through these orally.
My Lord, that leaves me with only one further thing to do, if I may, with your permission, and that's to give you some additional references that are not in the written case on one point.
Yes.
They are on the issue of competence. Yesterday, I outlined the different variants of the doctrine: Germany, France, United States, England. All I want to do, with your permission, my Lords, is to point you to two further authorities in the Respondent's Further Authorities bundle, which may be of use to your Lordships by way of background.
Is this your bundle? It's the ordinary.
It's the additional authorities. It's additional Respondent's additional authorities. It's labelled. Well, tab 1, there are some further pages from Mr. Vaughan's huge magnum opus on international arbitration. And at tab 5, there is an article we've included by Professor William Park, Rusty Park, at Boston University. Both of those materials set out, they're actually quite complementary together, and they give you the detail of the variants of the doctrine.
Tabs, which and 5?
It's tab 5 is Park.
Yep.
Tab 1 is Gary Bourne.
Yeah.
Those are the only additional materials to the written case.
Yes.
Lord, unless I can be of any further assistance, that would then...
No, well, thank you very much indeed for your help. Thank you.
May it please your Lordship?
Yes.
Can I start with some aspects of the nature of the exercise? I know we started with phrases which perhaps are more familiar to us, of rehearing a review, simply because one sort of needs a handle on what to distinguish the different nature of the exercise. But if for present purposes one looks at it more generally, the first point I'd like to raise is the issue of substantive jurisdiction, which came up yesterday afternoon, which I have dealt with in my case, on the issue of scope. Because although scope can mean an interpretation of a contract, i.e. whether the difference is a difference that is covered, it can also mean whether or not that particular party had agreed for that particular issue to be before the tribunal. So that it's not necessarily only a question of contractual interpretation. It has an underlying jurisdictional import. And that can be seen, and I won't take your lordships to it, but that can be seen from some of the Canadian cases, which I set out in my case, starting at page 146. And whilst a lot of them, in fact all of them, are dealing with annulment at the seat, the point of those cases really is twofold. One, they are under Article 34 of the model law. And the test under Article 34 of the model law is identical to Article 36 of the model law, which is the New York Convention. So it's those principles, it's unlike the English section 67. And what you see from those judgments is the deference that is given to the tribunal, even, for example, when you are looking at purely jurisdictional aspects as opposed to interpretation. You see that particularly in the NAFTA cases, where the issue is whether or not parties were parties which could come before the tribunal. And so one shouldn't, with respect, just dismiss scope as being something entirely different. And I won't, given the time constraints, I won't go through it, but it's set out in full in my case. And I would...
Paragraph.
It starts at
146, is it?
paragraph 146.
Well, page 146, rather.
No, paragraph.
Paragraph 146, sorry.
Lord Mayor. And then I summarise it at the end of those cases, and other cases, of course, are referred to as well, but the summary is 154. And the point being that when you look even at the English Act, under its definition of substantive jurisdiction under section 82, which refers back to section 30, includes not only issues as to the validity of the agreement, but also whether or not, well, just let me read the exact words, unless otherwise agreed by the parties, the arbitral tribunal may rule on its own substantive jurisdiction, that is, as to whether there's a valid arbitration agreement, whether the tribunal is properly constituted, and what matters have been submitted to arbitration in accordance with the arbitration agreement. And that, by section 82, is stated to be the meaning of substantive jurisdiction. So, the point of these comments is that if jurisdiction is based on consent, which I think everybody in this room agrees upon, such consent is not confined to what my learned friend calls the a priori situation, but it can also be a situation where there is the tribunal is constituted but takes upon itself something which the parties had not agreed that it would determine. For example, if you take in this case, instead of the issue being whether or not the GOP were a party, assume, for example, they were a party to an arbitral tribunal, but only for a particular dispute. And another dispute they had very deliberately kept outside the arbitral process. It would seem, looking at it logically, that it would be equally unfair for them to be brought before that tribunal if, on that basis, as it would be if there wasn't a tribunal constituted in the first place, if the issue is consent. So that...
yes, well, why isn't it equally unfair? I think Mr. Landau says it is.
Well, I think, with respect, Mr. Landau takes out the validity of the arbitration agreement. If you look at his case,
well,
he says that
in oral submissions, when this point was put to him, he said logically, there might be a slight presumption, or perhaps a strong presumption, that arbitrators got the scope of their jurisdiction right. But logically, the court has to re-examine whether they did.
Well, but the point being that when you're looking at the scope, and the only point I'm making from this is when you look at, because there is limited authority on this issue, but when you look at the Canadian cases, they are, albeit that they're cases at the seat, they are looking at the scope. And therefore, if the issue is one of consent, they are saying, that the courts in Canada are saying that even in such cases, apart from the situation where the issue is whether or not the tribunal is acting within its powers, the separate issue is whether there is jurisdiction, and therefore you have to give a weight to the award. That's the only point I'm making.
Well, is the point is that there's a sort of shading, as it were, of the force of the argument of absence of consent the further you go into the procedure. I mean, you accept, do you, that it's absolutely fundamental that there should be consent to the arbitration agreement?
Well, yes.
Absolutely an agreement on who the arbitrators should be and so on. But as you go into the process, if it's set up by agreement, you've got the agreed arbitration and so on, there may become matters of things that somebody might say was outside the scope of the award, but it would be a debatable issue. Is it that kind of thing?
It would depend on the facts of each particular case. And when you look at the NAFTA type cases, the issue is whether one of the parties should be before the tribunal, not whether the issue should be before the tribunal. That's the distinction I'm making. If you're looking at whether or not the party should be there, as opposed to whether or not the issue should be there, and if you're looking as to whether or not the party should be there, it should make no difference whether or not there was a tribunal properly constituted, or whether there wasn't one constituted at the beginning. I think that's as far as I can take it, but it's simply because it does give some guidance as to the nature of the exercise. The other point, just for your note, and I'm not taking you to it, the recent case of the Republic of Serbia does deal with the two sorts of jurisdiction, and that's at volume 277, and that's at paragraph, I think it's 113 of my case. where I said one.
No, doesn't look quite right.
I have set it out. I'm trying to say. I'm sorry. It's a page, paragraph 118 of my case.
I'm sorry, one?
Yes,
118.
yes.
118, thank you.
So you quote it's a passage from Mr. Justice Beatson.
It is indeed, yes.
And what is the particular bit that we should be
it's
looking
simply,
at?
again, just looking at the two aspects of jurisdiction. That there may not be quite the stark distinction that was originally thought. It is a building block, so to speak, in the nature of the process. And therefore the bootstrapped argument can apply to both.
I don't understand what he's saying here, except what follows from the Act, namely that you can, as an arbitrator, rule on your jurisdiction, but the courts can then reconsider the matter.
Well, he's saying that as well. There seems to have been an argument as to whether or not it applied to a situation whether the arbitrator... it's really this... yes, where the question is whether the position is different, whether the jurisdictional issue is whether a person or entity is a party to the underlying contract. It's the third paragraph. Obviously, there's an argument there that there was a different situation. It probably overturned the decision, but it was simply a recent decision on the point. So one comes back, therefore, to the competence issue, which I've already given you my submissions on. If I could just add to the lexicon of things for your Lordship to look at, and that's also Gary Ball, which is at volume 3, tab 100, page 872. Now, when we come to the New York Convention, and your Lordships have my submissions on the status of the award, if I could just bolster it by 2 points. When you, and really from Lord Nance in Yucas and Dardana, when you are looking at Article 5, the award is on any view in our submission provisionally recognised and enforced. And it must have a status because it is the antithesis to, for example, ground E, which would say that it was set aside. But also, if you're looking at Article 5 in the round, it must be a valid binding agreement because the court has a power to not enforce it on the grounds of public policy. So if one was looking at the public policy criteria, which we're not today, but if you were, the court would have to look at that award as an existing instrument and determine, according to that court, enforcing court's national law, whether or not it was against that own court's public policy. So it must have an important status, and we say it has a more important status than is alleged by the government of Pakistan.
It is interesting to see how that article is laid out. I mean, the public policy thing comes in Article 5.2.
Yes.
And there's a group there of the two things that are separated out. The subject matter is not capable of settlement by arbitration. That's assuming, I imagine, that you've agreed on this. You've got your arbitrators and so on and so forth, but you're met with the argument that you can't actually resolve your particular thing. It may be something to do with matrimonial status or something of that kind. But everything else, the agreements are all there. It's just simply an objection on this particular point. But I think the point against you is that this is a question of different levels as you approach the subject. And the further you go back to the very root point of the initial agreement, the more powerful the argument becomes.
It may well be that, as I think I've submitted, it is a question of the weight that you give, and it may be But take a public policy situation. I mean, Hebe is a good example, although probably there wasn't any public policy in that. But there are many cases where something is held not to be against the public policy by the arbitral panel, perhaps because it's a foreign law, but yet it would be contrary to the English public policy. And although it happens rarely, it does happen. But the status of the award, and after all, the enforcing court is doing a very similar exercise in the sense it is relying on a ground of the New York Convention, albeit it's subsection 2 as opposed to subsection 1. It still has a discretion as in subsection 1. But underlying that is Article 2, which prefaces both, namely that there is, at the very least, a provisionally recognised and enforced award. My Lord, it was said yesterday also that this is rather like Section 67. Section 67 is a challenge to an award. That's very different in our submission from enforcing an award. And that difference is recognised in the Convention itself because a challenged award, i.e. an award which is set aside, is a specific ground under Article 5.1 on which a court can or cannot enforce. So that the test of setting aside should not, in our submission, be the test that's applicable to enforcement. One has to look at the enforcement standing on its own as to what is the appropriate exercise. I move now from that, I'll come back to that.
The only reason that is so is that a recognising or enforcing court isn't the right court to set aside an award. All that is of interest under Article 5 is whether it's going to be recognised and enforced. And there are various grounds set out which, as my lords pointed out, operate at various levels of seriousness. But the enforcing or recognising court doesn't actually concern itself with those grounds in themselves. They're simply reasons for refusing recognition or enforcement.
I agree entirely, but the point I was making is that it doesn't, because it is a reason, it doesn't follow automatically that the manner in which the award is set aside has to be the same exercise as the manner in which an award is enforced, because you are looking to different things. One is looking to challenging the award, setting aside the award. The other is looking to enforcing an award, and they are different with respect. And therefore, whilst obviously my learned friend argues that they're the same, in our submission, that is not the starting point that they are the same, because one is enforcement and one is setting aside. If you set aside at the seat, then it is recognised, even though it is not always accepted, even if it's set aside, that it will be enforced. Once you've set aside the award at the seat, it's recognised it's going to have wider implications than if you enforce, perhaps not in this country, say in a small country, whose jurisprudence perhaps is not internationally recognised elsewhere. That enforcement may have a more limited effect on the underlying award than the setting aside. And the only point I make, therefore, is that it's not automatic that the test is the same.
But it could be that the country in which the enforcement issue arises is the only country where, in practice, the party who holds the award is going to get any benefit from it at all, the place where the assets are.
Well, that is right.
I mean, there could be these cases, and it doesn't matter. There are lots of other signatories to the convention and so on because there's nothing there.
Yes.
So it could be as important, couldn't it, in certain cases?
My Lord, I'm not saying it's not as important. I'm saying that under the convention, there is nothing which says that the test has to be the same. After all, the convention doesn't deal with it. And the test under the convention is whether or not my learned friend has proved. The test under the Article 67 is slightly different, and it will be slightly different in other jurisdictions. All I'm saying is that you have to look specifically at the test, may be important, but you have to look specifically at what the court is doing, and it doesn't follow that it's necessarily the same. Now, this morning we spent some time on transnational law, and I think to an extent there is a limited agreement between us that transnational principles are applied by the French courts. The issue being, as I understood it, whether or not the tribunal had applied the French law principles using the transnational principles. My Lord, you've been taken to Dallah, which is flag 6. There's also the commentary that I drew your attention to yesterday, flag 9 of B, the authorities bundle. Is that B1? The authorities bundle, which I think is B1. My Lord, a distinction was
Sorry,
made...
which one?
B1.
Well, the French law bundle.
French law bundle, yes. I took you to it briefly yesterday. I was really just giving you your notes, unless you want to turn it up at this stage. There's also a reference to a case called Gat Oil.
I'm sorry, what was your B1 reference?
B1, tab 6 and 9. There's also a less relevant case called Gat Oil, but Monsieur Durand refers to it as tab 11. I'd just like to make a few points on this. A distinction was made between what the French courts would do and what an arbitral panel sitting in France would do. But what we're looking at here is what the French courts would do when considering what an arbitral panel sitting in France would do. And therefore, in our submission, it's a distinction without a difference, because what you're looking at is what the French courts would do, in effect, what the French court will do in France when these contemporaneous enforcement proceedings are determined. And the expert evidence was agreed between the two experts that transnational law was a part of French law, and I've taken you to the joint memorandum. It was also agreed, and it was put to both witnesses, that good faith is a part of French law. And a reference, for example, of Monsieur Vattier, because it's only 2 sentences, I asked him, was good faith a part of French law? And he said yes. It's B, tab 5, page 104. I don't think we need to turn it up. But importantly, you will recall yesterday, and I don't want to take you to it again, but I put to Monsieur Vattier, who is the government's witness, paragraph 6 of the tribunal's award. And that was the award which refers to all the parties.
Common intention.
Common intention. And his answer, I mean, I can give it to you again, but you may already have a note of it. It's... But I specifically put that paragraph to him, and I read it to you yesterday. And his answer was, generally it's the right test. Here we are, for your note again, it's bundle B, flag 5, page 94. I'll just read it to you, rather than trouble you to turn it up again. Monsieur Vattier, could you read paragraph 6, please, to yourself? Have you read it? And then I'm awaiting a question. The question is that the correct test, as would be applied by the French court by way of common intention in a case or matter such as this? It is the general principle, yes. Now, I know criticism was made that, well, the tribunal went on to look at it in the context of the defendant, having said that set the test. But if you look even at Mr. Justice Aiken's judgments, it's quite clear that what he was trying to determine, because that's the real issue in this case, is the intention of the government. And rather than putting the test at the beginning, what Mr. Justice Akins did is he put the test at the end. I'm sorry.
Could I just ask this? Was there evidence or agreed evidence that involvement in the negotiation and performance of the contract raised a presumption about common intention?
I believe, let me take you to the...
Because there's no doubt the last three lines of paragraph 6 are common ground.
Yes. What the agreed statement says, but I think it was agreed in the oral evidence, but in the agreed statement it says, under French law, in order to determine whether an arbitration clause upon which the jurisdiction of an arbitral tribunal is founded extends to a person who is neither a named party nor a signatory to the underlying agreement containing that clause, it's necessary to find out whether all the parties, and then it deals with the negotiation, performance and termination. But what I can say...
So what is the reference to the agreed statement?
That is bundle B, flag 1 is the joint memorandum. But what I can say is that this was all... Monsieur Vattier gave his evidence, and it was agreed to, with one or two small points, by my expert. There wasn't any difference between them.
My question is simply this, and perhaps I didn't make it clear.
Yeah.
In paragraph 6, they say that involvement in negotiation and performance raises a presumption of common intention. 2.9 of the joint memorandum doesn't say that. It just says that you look at the negotiation, performance and termination.
But the evidence in the case do refer to the presumption. If I can take you to the relevant part of the evidence, it was certainly put in, as far as I can recollect, in evidence. I think it would... I can just find it. I'm sorry, forgive me one moment. I haven't got it exactly to hand. But the cases certainly refer to the presumption. I don't believe there was a dispute because my learned friend questioned, in fact, I was just going to take you to that, the case of Ori, where my learned friend put to my witness the issue about acceptance, which is part of the presumption. And that may answer your question. If you go kindly to bundle B at flag 5, at page 120. You have line 18, let's have a look at Ori, and then over the page he comments is there is actually no difference between all the cases, that's line 2, and then Mr. Lando pursues it at the page 122. Accept a yes, so it suggests from this that it is more than just being aware of the existence and scope, it's actually accepting. Yes, in any case, it doesn't change very much, because the idea is that it is aimed at establishing the common will of the parties. Yes, sure. I'm asked to refer to page 121. And if one looks at the cases, I think you would find that the cases which they were all considering obviously do use the phrase. The jurisprudence constant uses the phrase that it does raise the presumption.
Well, what raises the presumption? Simply being involved in negotiation and performance?
Well, let us look at the cases.
Whatever that means.
Give me 1 second. I'm just trying to find the best case that deals with it. trying to see. Perhaps I can just come back to that in a minute, rather than waste your... Oh, you've got it. Yeah. That's it.
I don't think you need-
Is a good example, but it's an earlier case.
Sorry?
At tab 22,
In E1?
E1.
Yes.
According to the customary practices of international trade, the arbitration clause inserted into an international contract has its own validity and effectiveness, which require that its application be extended to the parties directly involved in the execution of the contract and any disputes that may arise therefrom, provided it is established that the situation and activities of those allowed
Yes, I see.
allow it to be presumed that they accepted the arbitration clause of whose existence and scope they were aware,
Yeah.
even though they were not signatories to the contract.
But that's not supporting what the arbitrators say. That's not supporting a presumption which arises simply from being implicated in the negotiation or performance. On the contrary, it says that you can extend an arbitration clause to parties who are directly implicated in the execution of the contract and in any litigation which results from it, provided that it's established that their contractual situations, activities and their usual commercial relations raise a presumption that they've accepted the arbitration clause. So that, sorry, I was translating, but you've got to establish a large number of things. Look at the whole picture.
Well,
They've got to be, first of all, it's a condition they're directly implicated in the execution of the contract, but that's not sufficient.
well, another case is at flag 20, Cosnus Marma. Have you looked around?
But I'm not sure we need to go very
Yeah.
deeply into this, because the real issue is not so much what they say in paragraph 6, but what they actually did, isn't it? I mean, what they actually carried through when we see what they examined and how far they went into the activities and everything else of the parties.
Well, my lord, if one I was going to go to the award as you mentioned it. It 6 and 7 obviously looks at the test in the round, but the question they were asking themselves, and that was the issue in, of course, the terms of reference. Was the same issue that you have to determine, or the enforcing court has to determine. Does an agreement to arbitration under the rules exist between the claimant and the defendant? Does the arbitral tribunal have jurisdiction in respect of the defendant over the claims submitted in the present case? But when you look at their award, it is clear from places, I mean, one has to accept perhaps it could have been a better written, but it is clear that what they are looking at is the position of the arbitration agreement. For example, on page 19, at 2, however, it's well established as a basic legal rule of the international law of arbitration, international arbitration agreements are autonomous, and that such autonomy means, on the one hand, the arbitration agreement is separable from the main contract to which it relates, and that its existence and validity are to be determined on the basis of its own terms. And then, if you go, for example, to paragraph 3, where we have a further reference to the French test, judicial as well as arbitral case law now clearly recognise that as a result of the principle of autonomy, the rules of law applicable to an arbitration agreement may differ from those governing the main contract. Such rules need not be linked to a particular national law, and they refer to Dallah, but may consist of those transnational general principles. And then he says that whilst Dr. Shah and Lord Musker would not endorse without reservation a concept of national procedural law independent of all national laws, they needn't pursue this since it makes no difference to the result. And then, so far as the French test is concerned...
That might be consistent with their understanding that, as some of the French commentators have pointed out, Professor Meyer, I think, and Gaillard probably also. Transnational transnational law in this context isn't independent of all national laws. Actually, it's a function of French law.
Yes, well, that seems to
Might
be
be.
what... Yes.
So, I mean, they might be. The previous paragraph certainly seems to suggest that you escape altogether any national law.
But they don't seem to have been applying the French notion of transnational principles, do they? At any rate, not expressly.
Well,
See the end of paragraph 4.
well, except that, yes, paragraph 6 does refer to the phrase presumption that the common intention of all the parties was that the non-signatory party would be a true party to such contract and would be bound by the arbitration.
But this presumption is based upon what? A mere fact that they were directly, as formulated in paragraph 6
Yes.
anyway, the proposition seems to be that if you're directly involved in the negotiation and performance of a contract, it's to be presumed you're a party to it. Not only you, but the other party presumes that you're a party to it.
Yes,
But that's a very truncated version of the French principle.
Well, my lord, it's possible...
Whatever Monsieur Vattier said.
If you look, a short way of summarising it is if you look at bundle B, flag 3, which is the report of Mr. Durand, and he gives the various cases when he talks about the constant case law.
So where are we now?
Flag 3. It's just that it's...
Which page?
Well, he first of all deals with, page 15, he deals with paragraph 18, Dow Chemicals.
Wait a minute.
Which, and then he says that over the page 16, the decision of the Paris Court of Appeals is enlightening, as it shows under French law, common intention of the parties may be implied, that such common intention may be revealed by their behaviour at the time of negotiating, during the performance and at the time of termination, and that's a group of companies issue. It's not a determining factor, as it is considered by the court as a subsidiary element. The last observation explains that in future decisions of the same effect, the Paris Court of Appeals was able to generalise this approach by constantly declaring an arbitration clause in an international contract as a validity and effectiveness of its own, such that the clause must be extended to parties directly implicated in the performance of the contract and in any disputes arising out of the contract, provided that it has been established that their respective situations and activities raise the presumption that they were aware, and the later case was a gloss accepted, though Mr. Durand said it was the same, of the existence and scope of the arbitration clause, and irrespective of the fact that they did not sign the contract containing the arbitration clause. So what raises the presumption is the fact that you are involved. It's the behaviour which raises the presumption. And
Well, no, I mean, that's actually not right. And that it does seem interesting that the arbitrators in paragraph 6 use the phrase directly involved in the negotiation of the contract, or directly involved in the negotiation and performance. The words directly involved clearly look as if they come from the French case law.
Well, they come from Ori.
Yes, from Ori.
They're certainly there.
Yeah, but in fact, the test which the arbitrators apply is not a correct reflection of the full Ori test.
Well,
The Ori test is looking further, looking at the execution and any disputes that may arise therefrom. So it's not just the negotiation of the contract.
no, but if
But also, you've got to establish that the contractual situation, activities, and habitual commercial relations
Yes, allow it.
allow the presumption.
But with respect, you need to look at also paragraph 7, which elaborates paragraph 6 of the tribunal,
Well,
Yes,
the various
that's looking-
stages.
That's just what they're looking at. It doesn't.
My lord, I was going to take you to the Dow Chemical case, or at least to ask you to look at that, because that was, as that extract showed you, was in fact referred to and upheld by the French courts, and it's a case I'm sure you're familiar with. It's just for your reference. It is flag 7 is the award, flag 8 is the Paris Court of Appeals in bundle B1, where the Court of Appeal looks at, in that case, as Mr. Durand says, the involvement of the parties in the performance and the termination of that contract in order to determine whether or not they were parties to the arbitration clause.
But there's something extra in it too, is there not? I mean, if you look back to the Ori formula, we've got to look also at the situation of the parties and the activities of the parties.
Yes.
So involvement itself is a very loose expression, even directly involved. It could just be at a third hand, separated out, properly providing encouragement, finance, whatever else it might be, but not actually getting to grips with being a party. And it's that's why the situation and activities are important, because you've got to look at those as well to see whether they raise the presumption.
Then you've got to look at also with respect at what they actually did. And when you go through the award, they are going through specifically involvement may be a shorthand for activities. They were summarising what the test was. What you have to see is the process that they went through. And it's quite clear that they went through the process of looking at the position early on, looking at the position at the MOU, looking at the change of position at the time of the termination, and critically, looking at the position after the lapse of the trust.
What they don't do, though, is they don't analyse the contract. I mean, the agreement. They don't say, well, here's the agreement. Let's look at the agreement. Let's see how it came into existence. Let's see what the parties must have intended. What was Dallah saying? Were they saying, well, let's add the government as a party? They don't do that at all. And indeed, the arbitrators, it's right, isn't it, that throughout, from paragraph 7 onwards, they're simply focusing on what the defendant did. Whereas it's a two-stage thing, isn't it?
Yes.
I mean, we don't get anything, not a hint of what Dallah did, not a hint of it.
Yes, but
Yet Dallah drafted the contract. I mean, you would have thought they'd have considered why it was that Dallah drafted the contract in the way they did, or their lawyers drafted it. Undoubtedly on the footing that the government would not be a party.
Well, my lord...
But where is that in the award? Not a hint of it. Not even a mention of it, as far as I can see.
My lord, I accept that it's perhaps not as...
But I mean,
as
where... they don't anywhere consider the position of Dallah, do they? Anywhere. And if so, if they do, please point it out.
Well, they deal with... sorry, I just lost this. Yes, I'm going to 10.1, top of page 31. Both exchanges of letters continue to be made between the claimant and the defendant and not with the trust, although such trust was in existence and operation, and having signed the agreement was responsible for its implementation. But my lord, it may, on the French test, assume against me for a moment that the position was, as at the date of the trust, it's clear that Dallah was contracting with the trust. That still leaves it open for me to argue.
I follow that, but that's not the way the tribunal did it. They didn't say, well, now, as at that moment it's perfectly clear that the trust was to be the party and that the government wasn't, but when you look at the whole picture, you see it was changed. They don't do that. Well, they seem to have jumped the whole of that. Whereas, I mean, there's no doubt, really, and I think you really recognise this, as you really have to, that when one's looking at the earlier stages before January 1997, the picture's really pretty clear, or at any rate, before late 1996, anyway.
Well, the position certainly changes at the time of the failure to re-promulgate. I have to accept that. But what you also have to recognise with respect is you will see the importance that this tribunal placed on the letter. If you go to page 32, such letter is very significant. What one doesn't know is if they, and I have to accept this, that if they ignored all the earlier stuff, would that letter on its own have been sufficient. And in our submission, under French law, it would be. But of course, when we come to look at the facts...
I follow that, but part of your argument is, here is this tribunal, they're a brilliant outfit, everybody knows they're very brilliant international arbitrators, and there you have it, what more do you want? But actually, they don't really begin to conduct a detailed analysis of all this. I mean, I'm not saying you would follow from that, that you may wish to say they should have done, and so on, but it does make it very difficult for us to say, well, you start with the tribunal, what more do you want?
Well, my lord, I don't go so far as to say that is all you have to do.
No, I quite see it overstate your case a bit, I agree.
It's a question of weight, and what a court has to look at is whether, at the end of the day, was the result on the facts correct? And it may be that it could have been better expressed. The Canadian court says that. But the question was the end result right according to French law? And as your lordship knows, what my learned friend has to do is to prove under French law that they were not a party to the agreement throughout the period. If the government behaved as a party towards the end, then that is sufficient. There are the additional arguments that I made earlier, and I won't repeat, as to what the status was in the earlier stage and the reason for the structure being brought about by the government's desire to have a Sharia-compliant financing arrangement. But the key moments are at the end, and the key moments really start with the letter in November, just after the change of government, when the government are being chased, the Minister of Finance and the Minister of Religion, to come back on the financing. And the letter is, just to give you the reference, I won't ask you to turn it up. We looked at it the day before yesterday, at page 314.
I think
we had signed the agreement on the 10th of November, and he's writing to the government to chase them up. And then you have the position that the government effectively removes the counterparty. Now, under English law, you may say they've induced breach of contract. But under French law, that brings them into the contract, so that my clients would have a remedy against them.
Can I take you back to Lord Clark's question about the fact that they appear to concentrate entirely on the defendant? I think you could say, if you look at paragraph 5, that they do actually refer there to the parties in the plural.
Yes.
I mean, the problem for you, I think, is that they don't pursue this in detail later on, but they flag up at the beginning in paragraph 5, in 2 places, I think at least, that they're looking at the actions of the parties in the plural, true intentions of the parties in the plural. And then you get your paragraph 6. So I think you can say that to begin with, at least, they seem to be getting close to the point that they should be examining.
And in
The trouble is, there's no analysis of Dallah's intentions at any stage.
Well, that's where it begins to break down. But having set themselves up with what seems to be the correct approach, then they don't pursue it. But, I mean, you're at the stage of making a reply, if I may say so, Ms. Harper, to the points taken against you. You've had your principal argument, of course.
But just to take that point, if you look at paragraph 119 of Mr. Justice Aikins, he's looking at the state of the mind of the government. I mean, the reality is in this situation that, as at the critical period, what everyone was looking at is the state of mind of the government, and both the tribunal and Mr. Justice Aikins both set out the test. Therefore, it clearly was within their contemplation.
Just dealing with the point you made a moment ago about looking at it at one moment, and it's sufficient if the moment is at the end. The fact is that during the 1998 proceedings, which I take it you have, among other things, in mind, although the government of Pakistan's attitude was that it had become party to the agreement on the demise of the trust, nonetheless, when it commenced the 1988 proceedings, its attitude was that it was no longer party to the agreement, let alone to an arbitration clause, and it was seeking a declaration and an injunction on that basis. So that viewing the fact that arbitration agreements are what we're talking about and are autonomous, it's a bit difficult to say that there was any common intention at that point to be a party to an arbitration agreement, however much your clients may have wanted the government of Pakistan to be.
Well, if you look at two comments on the 1998, if you look at actually, which we did yesterday, and I don't want to go back on them, at the 1998 pleadings, they are saying that they have a cause of action, and that the whole purpose of the proceedings is to show that the contract's come to an end. And
Yes, well, that's precisely the point I'm putting to you.
Yes.
They're actually seeking, as a consequential relief, a permanent injunction on the basis the contract isn't binding and is of no consequence upon the rights of the plaintiff. In those circumstances, it's a bit difficult to say that there was a common intention to be party to an arbitration agreement.
But no, not binding, not because it was never binding, but not binding because there was a repudiation which they accepted.
But how can you say that you're party to an arbitration agreement if, however misguidedly, you say, all right, I once was, but it no longer exists?
Well, one could say with respect the same in relation to the earlier proceedings. How could they say, therefore, the trust had ever been a party to the agreement? I mean, that was the 1997 proceedings. And one thing that was said in reply, which I perhaps should deal with, is that the 1998 proceedings came about as a result of encouragement from the judge. My Lord, there's not a scrap of evidence that that is the reason. If one was tossing a coin, it's 3 months since the judge made his decision. It's 3 days since the proceedings had been launched in the ICC. So one doesn't know why, though. This is the whole problem with the... This is the whole problem with the nature of the exercise in this case. It's the whole problem when you... And it is to an extent an exceptional case because you've got no new evidence here. There is simply the same evidence, and it is an interpretation that is being made by the court as to what that evidence means. And we went through earlier the different stance of the government at various stages in the Pakistan proceedings, in what they said to the tribunal. And as Lord Clark said, the witnesses haven't been tendered for cross-examination. And any court, when they have got evidence which in our submission is certainly susceptible of different interpretations, must attach a different weight to that than if the government had come along with witnesses, with documents. All they have done is relied upon the very same evidence. And Mr. Justice Aikins has, by reading into some proceedings, the motive for which we do not know, a particular gloss on that letter. But in our submission, it is a sort of letter that could be susceptible of an entirely different gloss, added to which you have got the act of the government in actually failing to re-promulgate the agreement. So you have got a double whammy, so to speak, of the government involvement at the end of the day. And in our submission, when one is looking at the exercise that a court has to give when enforcing, remembering that the onus is on the government, and whatever the exercise is, whether it's a rehearing, a review, it is for the government to prove this fact. And one has to remember also that the first time that the argument developed in the way it did, and I'll be corrected if I'm wrong, but my recollection was that it was in my learned friend's skeleton that it was the first time that reliance was placed on the 1997 proceedings. Because before that, and just one document two documents I would just like to take.
By skeleton, you mean for this court?
Before Mr. Justice Aikins.
Oh, before Mr.
No. He has been running it ever since Mr. Justice Aikins. But it was in my learned friend's skeleton that this argument first appeared. As far as I'm aware, there is no document prior to that which says, well, of course, we launched those proceedings in order to preserve, as Mr. Justice Aikins said, some rights which we thought the trust might have. And one has to remember also that lawyers have been involved throughout. Lawyers were involved when those proceedings were initiated. And if one's speculating, as one could speculate ad infinitum in this case, one could speculate that the letter of the 19th of January was written by lawyers. It was sent on the 20th. It was relied upon in the pleadings. One would assume they'd been drafted about the same time. But certainly the lawyers would have seen it when they drafted the pleadings. There were lawyers involved, albeit without prejudice, at the ICC, and there have been new lawyers involved throughout here. So, my Lord, one has to look at the evidence with a certain measure of scepticism. And also, if one goes, please, just to bundle A, which is just to see how it was put by Watson, Farley and Williams when the application was first made to resist. You go to flag 11 at paragraph 15, and one would assume this is done on the instructions. Is that right? Yes. By a letter dated, just one paragraph. By a letter dated the 19th of January 1997, the government...
I'm so sorry, which tab are you in?
Tab 11.
Tab 11.
The government of Pakistan informed Dallah that it was in repudiatory breach of the agreement, having failed to submit specifications and drawings within 90 days, and notified Dallah that the repudiation was accepted. The government of Pakistan also notified Dallah that its failure to arrange a financing facility within 30 days prevented the agreement from becoming effective in any event. Dallah denied the government of Pakistan's allegations and in turn accused the government of Pakistan of breach of contract. Now, this was in support of the opposition to the leave to enforce on the basis that the government was never a party to the agreement. Nonetheless, in that witness statement, it says that the government of Pakistan, not the trust, informed Dallah. And that was dated the 23rd of March 2007. Some 16 months later, we get a second witness statement at paragraph 12.
Tab 12.
Tab 12, page 159. This was shortly before the hearing before Mr. Justice Aikins. In paragraph 15 of my first statement, I suggested that the letter dated the 19th of January was written by the government of Pakistan. I've now read the application made on behalf of and in the name of the trust in the Pakistan courts on the 20th of January in relation to the repudiation of the agreement and the other documents filed in the name of the trust in these proceedings. And I realise that the statement was incorrect. It appears from these documents that the letter of the 19th of January was in fact written by Mr. Luftullah Mufti in his capacity as Secretary of the Board of Trustees and or Managing Trustee of the Trust, a fact which the judge said it couldn't be, in the name of on behalf of the trust. To this extent, paragraph 15 of my first witness statement is hereby corrected and should now read as follows, and then he amends it. But it couldn't, of course, have been written in his capacity as Secretary of the Board of the Trust because the trust didn't exist and the judge so found. So what I'm trying to indicate to your Lordship is this is an argument that has been built on by those arguing on behalf of the government, but there isn't any evidence. It was said that there was a mistake, but there's no evidence of a mistake. And it is, therefore, a very unusual case that this should turn, given the history of this case and the different stances simply upon a reading into a contemporaneous commencement of proceedings. And therefore we would urge you to look very, very carefully to that critical distinction which was made by the judge as opposed to the way the tribunal looked at it. And my Lord, so far as the presumption of an arbitration clause is concerned, it is also important to bear in mind that the government was involved in the drafting of this agreement. And it was the government who was involved in changing the arbitration clause. And one can see that from Bundle C at two documents. My learned friend referred to it in his argument. The first document is at page 178. This is the Finance Division. You needn't look at anything except the arbitration clause 179. In case of dispute, arbitration will be held in Pakistan under Pakistan law. So that's how it started. It then went to the Minister of Religious Affairs, and you see that at page 182.
Sorry, whose document is this?
This is a document from the Ministry, the Finance Division, Government of Pakistan. It was said by my learned friend that the government looked at it, and therefore he makes the point that the government knew what they were doing by putting it into the name of the trust. But I'm making a different point, namely that when one is looking at whether or not the government is presumed to have accepted an arbitration clause, when they were involved in the drafting of that agreement, if they accepted the agreement, they must have known of the arbitration clause. And if you then go to page 182, 29th of August, that's 2 weeks before it was signed, paragraph 2, it's further stated that the agreement also requires the following changes amendment. 2. In view of the observations of the Ministry of Finance on clause 24, clauses 23 and 26 would be required to be deleted. So the evidence we have is clearly whatever, because the government approved this agreement at the end of the day, whatever arbitration clause was included, the government knew about it. And the government would have known what was agreed by way of the arbitration clause. So we say basically that the evidence here is speculative, and when an English court is carrying out the exercise, whatever the extent of the exercise, if it is an exercise which starts completely from scratch, effectively ignoring the tribunal's findings, it is an exercise here based upon the very same evidence with a gloss put simply upon a set of proceedings.
Well, I think you're at risk of repeating
And that's,
yourself.
I'm
You've
repeating
made this
myself.
point
My Lord,
many
let
times.
me move to one further point, and that is that the government, of course, could have resurrected, as I mentioned earlier, the trust retrospectively and then brought proceedings in its name. So, my Lord, I don't want to repeat the points that I have made, but when you are looking at the exercise, we would submit that even if the tribunal reasoning could have been better, and it would have helped my argument if it had been clearer, if one looks at the Canadian cases in analogous situations, that in itself should not be a reason why, if the result at the end is correct, that it necessitates a complete rehearing, ignoring what had gone before, and effectively substituting the English court's view, applying French law of what the position was here. Yes. Because at the end of the day, the onus is on the government to prove that it was not a party, and under French law, it has to do that from beginning to end.
I think we have that.
And I think that concludes my submission.
Could I just ask you one question arising out of this morning's submissions by Mr. Landau, namely how the case was put to the tribunal? I'm a bit confused about that. We saw the letter. In the period before the letter from the arbitrator, which we looked at, one of the arbitrators we looked at this morning, do we have the submissions that were submitted to the arbitrators before that?
My Lord,
presumably there were written submissions to the arbitrators.
My Lord, the position, as far as I can relate, and as far as I've checked, was clearly, initially, the battle was Pakistan law, Saudi law. I cannot remember at this stage whether or not I raised any general principles in oral argument. I didn't in the initial written argument.
To the tribunal?
To the tribunal. I simply can't. I have a feeling I did, but I wouldn't like to say I did because it's so long ago I can't remember. There was.
But when was the idea that it might not be either Saudi law or Pakistani law? When was that live? Was that live during the actual arbitration before the letter?
That's what I cannot 100% remember, because it's some sort of 10 years ago.
It's right that you were essentially, because I just wondered if we have here any written submissions before the arbitration.
I have got, if the tribunal wants them, I have got the written, I believe, what are the written submissions I made. What I don't know is whether or not, of course, the government put in, and I can't remember, put in written submissions to the tribunal in response to the same points.
In the original claim for arbitration, the case was put on some sort of agency basis.
It was indeed, yes.
And that rather fell by the wayside, didn't it?
Yes, it did.
And then there was the alter ego point and the succession point. They were live before the arbitration.
Well, I think the position is... Oh, we have got it. I'm sorry, we have got it. I didn't read. The response that we put into the letter is at flag 8.
Which bundle?
Of bundle D.
A bundle?
D.
Just remind me where the letter was.
D. The letter is, I assume, is...
It's in the new documents, apparently, yes. One of these additional... Is it?
No, I'm not sure that's
Don't think
right.
so, no.
Sorry, no, I think that's a wrong... no, it's wrong.
No.
I'm sorry. I've given you. No, there is a document which I found on
It's D.
in response that we put in.
And which tab in D?
In response to D9.
Yeah.
That's the letter.
That's the letter. We put in a response. I do not believe it specifically dealt with common intention as such.
Is it in the bundle?
No, it's not in the bundle. But I do have it because I drafted it, albeit 10 years ago. I don't believe, because I looked at it quickly over the weekend, that it specifically refers to common intention, but I would have to double check. But what we don't know, and what I can't remember, is whether or not there was a response from the government to this as well. So, in a sense, I'm reluctant to give it to you because it presents only half the picture, because I don't know what the government said in response, if they did, to this letter, whether they replied or not, and I don't know the answer to that. Well, they would have replied without prejudice, obviously.
Yes.
Yeah. But the transnational principles emerged during the process. What, again, I can't remember is whether or not, because looking at their letter, I have a vestigial recollection that something may have happened in the oral hearing, and then it was followed up by the letter.
But there was no actual French law evidence, was there, or was there?
No, there was no French law evidence.
And judging by what they put in the narrative at the beginning of their judgment, they were presented with two different systems of national law.
Yes.
So
that was the battleground,
yes,
to start with, and
indeed.
they clearly, although they took a different view when it came to the actual agreement, where the battleground was the same, they concluded that was Saudi law. For the purpose of the arbitration agreement, they took a different view.
Well, is there anything more you
I don't think
you
so.
need to say?
Sorry? Well, my lord, I think other than really the ultimate position that my clients find themselves in is namely that they have incurred expense and they have an award against them which is not being paid. This is 10 years down the line, and it is a factor, obviously, which your lordship will bear in mind in looking at the overall aspect of this case. My lord, unless there's any other further points, I'm conscious that there's a great temptation to repeat oneself, and I don't want to do it again.
Yes. Well, I think the court is extremely grateful to counsel on both sides for their assistance. We will take time to consider our decision.